We work with lots of tax advisors, family offices, trust and estates attorneys in coordination representing our clients. And I've found that by far and away, the favorite visa of tax, trust and estates advisors is the F-1 student visa. That is principally because an F-1 student visa holder is something called an exempt individual, meaning that the days that those clients spend inside the United States don't count towards the substantial presence test. And meeting the substantial presence test can have a very big effect on a client's tax exposure. So the F-1 student visa is a very simple, straightforward way for a client for 5 years to be considered an exempt individual. Downside of the F-1 student visa is probably twofold. The first is that a client really does need to engage in a full course load of study. So depending on where the client is in terms of their personal or professional cadence, the F-1 student visa can sometimes not make a lot of sense. The second downside has to do with stricter scrutiny that's being applied to the F-1 student visa writ large. So as we know, clients are subject to much more vetting when it comes to applications for F-1 student visas at consulates abroad. For example, we need to list and make public all social media accounts that clients have when applying for an F-1 student visa. Additionally, the Trump administration has indicated that they are interested in rolling back the STEM 2-year OPT extension and potentially trying to get rid of OPT as a benefit for student visa holders entirely. So F-1 student visa, very simple, straightforward, does the trick from the perspective of making sure that the client isn't subject to the substantial presence test. There are downsides in terms of the client being able to do whatever it is that he or she wants in the United States. And if they are, ready, willing, and able to take on a full course load of study and make all their social media accounts open and public ahead of their interview.